So, whenever you are given a case, read the facts of the case very carefully and try to identify a certain basic pattern which is shown here. First, identify what was the act which was committed. Or it could be that there is an act which is supposed to be done, but it was not done by the person. Second, identify was there a fault in that act. Simply doing something does not make it wrong. But if there is a fault in the way it is done, or there is a fault that the act is done in the first place, that may lead to a case. So let us say there is an act or the omission of an act. Let us say there is a fault. Now, identify, was there some protected interest of the other party which was damaged? Let us say I have done something and there is a fault in the way I do it. But if there is no damage to a protected interest of the other party, then there is no question of a case arising. Right? But in case, let us say there is an act or an omission, there is a fault, there is some protected interest of the other party which has been damaged. Then and only then arises the question of liability. Liability is the person who has committed the wrongful act liable, responsible for paying damages or compensation to the victim, or is he liable or responsible for undergoing some sort of a sentence or whatever? So remember that we have to look for this pattern when we are trying to identify whether there actually can be a tenable case or not. So let us understand this pattern thingy with an example. Let us say there is a boy, Ram, and he is driving his car carelessly, with the result that it mounts, it climbs the pavement and it hits another person, Bharat. Now Bharat is a pedestrian who is walking on the pavement and Ram's car hits him. It causes Bharat some sort of physical, personal injuries. Now my question could be that, is Ram liable? Now before we rush into answering that of course Ram is liable or whatever, let us try to see whether the pattern that we talked about is actually visible in this example or not. First thing that we talked about was the act. What is the act? So it is Ram is driving the vehicle. Now, is there a fault in the way he is performing this act? Yes, he is driving the vehicle carelessly. In fact, his vehicle has mounted the pavement, which it is not supposed to do. So yes, there is an act. Yes, there is a fault in the act. Was there some sort of protected interest of Bharat which was damaged? Yes. Every person has a basic, a fundamental right to safety. And because of Ram's fault, Bharat's fundamental right to safety was infringed upon. He got hurt. So there was an act, there was a fault in the act, and there was a damage to a protected interest. And because of these things, we can clearly claim that yes, Ram is at fault, Ram has liability, Bharat will win the case. Now, there are a few concepts that we need to understand as far as as far as liability is concerned. Right? And these are Latin maxims which often turn up in exams, but we need to understand what they mean. So the first one I'm going to talk about is something known as damnum sine injuria. Damnum sine injuria literally means a harm without a legal wrong. Which means, I have caused you a harm. It could be a physical harm, it could be a mental harm, it could be an economic harm. I have harmed you in some way. However, there is nothing wrong according to the law, and hence I will not be punished for it. So the basic point is this. Is it possible for me to harm you in some way and yet not be a wrongdoer in the eyes of law? Sounds strange, but let us take a look at it. Let us say there is a person A and he opens a fruit shop in a particular street, and B already owns a fruit shop. Now A is the new fruit shop owner and he has some sort of enmity with B. So what he does, he checks out at what price is B selling his items, and purposely starts selling the same items but at a considerably lower price. Why? His intention is that whoever used to purchase the fruits from B should now start purchasing it from him. So obviously, if you are going to get the same quality of an item at a much reduced price, you would go in for the cheaper one. So all the people go to A's shop, purchase from A, and B ultimately has to close his shop. He loses all his business. Now the question here is, can B approach the court of laws and claim that he has been wronged by A in some manner? The answer is, although A intentionally ruined B's business, in the eyes of law, he has not committed a legal wrong. Right? Keeping aside facts, things like competition law or minimum price of items or whatever. Take this as a simple situation. Has he broken any basic legal rule? Has he broken any article or any section of any law? No, he is simply conducting a business in a lower manner. He has not legally harmed B, and hence, although his intention was malicious, although he did want to ruin B, legally A cannot be held liable. On the other hand, there is also a maxim which says injuria sine damn, which says that for a particular act, it can be actionable even if there is no actual proof of any sort of damage. Which means, I have not been physically harmed, I have not been economically harmed. In fact, there is no harm which can be shown I have suffered, and yet if I file a case against you for that particular act, I will win. How is it possible to win a case when I have not been harmed in any way, either physical or mental or in an economic way? Let's take an example of trespass. Simple trespass. Let us say I own a particular piece of land, and on the other side of my property is the place that you want to reach. You have two options. Either you go around my huge property and reach your destination, or you jump the fence, walk across my land, and through this shortcut reach your destination in a short span of time. Now, for you, jumping across the fence and walking across my land would seem a good option. And if you walk on my land, I'm not going to suffer anything. Is it that my land is going to get polluted, or is it that I'm going to lose money or reputation or anything? Nothing. But I have the right to prevent any stranger from walking on my land. I have the right to say trespassers are not allowed on my land. So, in case I catch you trespassing, although I am not going to suffer any physical or mental or economic loss, because my legal right of not allowing trespassers on my land has been violated, I can file a suit against you and I can win the case. Now, this seems like a very trivial thing. Why should I go about suing people for simply walking on my land? But that's not the point. The point is, the law allows me to not allow strangers on my land, and if I want, I can implement this right of mine and win a case. So, damnum sine injuria, injuria sine damnum. Where, on one hand, you have some sort of physical, mental or economic loss, but there is no legal liability. On the other hand, there is absolutely no proof of any damage, but yet there is the question of legal liability. Right? So, what is important? Not the damage of property or the damage of person, but rather, is there a law which has been broken? That's the only thing you need to examine to check if there is liability or not.